So, thank you for joining us for today's ABA Civil Rights and Social Justice program, How Things Work, the Legal Edition. These videos address current critical legal developments that affect civil rights. They're a unique opportunity to break down challenging and important legal issues, clear up misinformation and disinformation, and describe actions that can be taken to protect rights. Today's topic, immigration detention, has been the subject of a lot of public attention, but there are often misunderstandings about what immigration detention is all about. As we'll discuss as we get further into the video, detention is impacting greater numbers of non-citizens than ever before, at the same time as the second Trump administration has issued new legal interpretations that strip many migrants in detention of due process protections. So today's talk is going to be a conversation between me and my co-panelists. So I'll introduce myself quickly. I'll let my co-panelist introduce herself, and then we'll just jump right into the dialogue. So I'm Denise Gilman. I'm advisor to the Commission on Immigration, and I am normally a professor at the University of Texas Law School, co-directing the Immigration Clinic. So I've been doing work on asylum, border issues, and immigration detention for about 20 years.
Hi, everyone. My name is Nareeneh Sohbatian, and I'm a member of the Commission on Immigration. I am, in my day job, pro bono counsel in immigration at a large non-immigration firm, and we work with nonprofits around the country on humanitarian immigration issues. So we are really looking forward to our chat today about immigration detention.
Thanks. So let's just get started. So what is immigration detention exactly? What is the nature of immigration detention?
So, surprisingly enough, immigration detention is not criminal detention. In most cases, detention is not because an individual has been accused of a crime. And even if a person has been accused of a criminal matter, there is a criminal proceeding that is entirely separate that is occurring and does not have to do with the immigration detention. While one has a right to counsel in immigration, it is not counsel that is paid for by the government. So an individual needs to secure their own counsel or else they will not be represented. Oftentimes, while we call them detention centers, immigration detention centers look a lot like prisons. They're not supposed to be punishment, but taking a look at the centers and going into the centers, there are metal bunks, there are cells, there's razor wire, and oftentimes they are run by private prison companies.
And when is somebody detained? How does a non-citizen land in detention? Why are they there?
Historically, immigration detention would happen in connection with proceedings in immigration court to determine if an individual is removable. So if they are ineligible for an immigration benefit or relief and will be removed to a country. However, detention does not always mean deportation. Some people will face removal proceedings without being detained, while on the flip side, some individuals will be in detention and will win their case and will be released from detention and will have an immigration benefit that they secure.
What's an example of an immigration benefit that somebody might get in removal proceedings?
It can be a green card, which is called legal permanent residency. It can be asylum. There are a matter of various immigration benefits.
Great. So why has immigration detention been so important in the public eye lately? What has happened? What's changing in recent years that has led to all of this attention?
We're seeing that the numbers in detention have been increasing for several years. There are several 100,000 people each year that are detained. It's about 70,000 each day. And most people, what we're seeing now is that they are being detained, and even when they are complying with their immigration proceedings, even when they are following the laws, they are being detained, and there are many complications and many issues that have arisen with the possibility for release on bond and limits on the review of detention.
And who's in detention?
So we are seeing people who have been granted certain types of immigration relief, but they are being detained while the Department of Homeland Security is trying to remove them to a third country. We are seeing individuals who are denied the opportunity to request bond because of the change in policies that we'll be speaking about in a little more detail. And really, it's a variety of people. Anyone at this point in time can really be detained. And so now I'm going to ask you, Denise, once someone is sent to immigration detention, how do they get released? Can people get out on bond?
Yeah, so the US Constitution is the first part of this discussion because the Constitution, under the Due Process Clause, says that liberty is always the presumption in the United States, and detention requires a special justification. Usually, in the immigration context, the justification is supposed to be that there is a flight risk, the person won't attend their hearings, or a danger that needs to be prevented by detention. So really, the case should be that a person shouldn't be detained at all in the first place or should be released if they don't actually present a flight risk or a danger. And there used to be a process that made that pretty feasible to filter through those questions. So it used to be that most non-citizens in detention could ask ICE to be released. ICE would be the person, would be the agency detaining them. And then if ICE did not wish to release an individual and said that they did present a flight risk or danger, then the non-citizen would have review in the immigration court to question the reason for the detention and try to get out often on a monetary bond or sometimes even on recognizance during the ongoing proceedings. There were always some people who didn't have the ability to get that immigration court hearing on detention, and those were folks that were subject to mandatory detention. In those cases, ICE could still release somebody. They always had that authority, but they didn't always, a non-citizen would not always have the right to have a hearing in immigration court. And I've put up a little graphic that tries to explain the way this has traditionally worked, where there would be this opportunity in most cases for review in immigration court. What's happened now is that it's much harder to get out of immigration detention once a person has been arrested. It's basically the opposite of what it used to be and what the constitutional framework really suggests. It's now the case that the assumption is that once somebody is detained, they will remain in detention, and very few people have any chance for review of their detention in immigration court. The bottom line is that now the only individuals who have the right to an immigration court hearing to review their detention, we often call it a bond hearing, the only people who have that right are those who entered on a visa and then fell out of status. And ended up in removal proceedings. So those who entered the country 30 years ago and were just picked up recently and put into proceedings, those who were in the country after having been here and were attending ICE check-in appointments and were picked up, most of those are now being treated as though they are subject to mandatory detention and no longer would have any ability for a hearing in immigration court to determine their custody, to determine whether or not there's actually a flight risk or danger, and if it is a possibility that they could be released, to set a bond and allow them to be released. So that's kind of the current state of affairs in terms of who has a chance to get out of detention.
Mhm. And so then what is there anything that can be done? You've talked about some of the changes we've seen. I know that there's been some case law. I don't know if you want to give us some more of the specifics on the case law, or shall we talk a little bit about what can be done, if anything?
Yeah, so let me just give a little bit more of an explanation of how we got to this place, kind of the before and the after time, because this is where there is a lot of, I think, confusion and misinterpretation of the law. So again, so the before the most recent interpretations of the law, and these were really interpretations that came down in 2025 under the second Trump administration. Before those interpretations of the immigration detention statutes, anybody who crossed into the United States, either with a visa or without a visa, but who made their way into the United States before they were apprehended, would have that ability to ask ICE for release from detention. And then, if ICE did not wish to release from detention, to go into immigration court. And as I say, there were always some limited exceptions. We called those the mandatory detention exceptions. It was mostly for people who had certain criminal histories. They would not have that right to go into immigration court. Now, under the 2025 interpretations, the individuals who crossed into the United States without a visa, however long ago and under whatever circumstances, including as an asylum seeker who entered the United States fleeing danger, those individuals who crossed into the United States without a visa, they are no longer eligible for review of their immigration detention in immigration court. No chance to argue that they're not actually a flight risk or a danger and should be released on bond. And the way specifically that this happened is that there were several different cases that came out in 2025. The first one was a case called Matter of Q. Lee, and then the second was a case called Matter of Yajur Hurtado. These were decisions by the Board of Immigration Appeals, and they are decisions that interpret the immigration detention statutes to say that the old rule that said as long as you crossed into the United States, you had this right, that is not a proper understanding of the statute. So what can we do about it? We can challenge this new interpretation of the statute. And so that's what I wanted to ask you about as well, as I know that there has been quite a bit of habeas activity on this very question of, does this new interpretation of the statute make any sense? Can you tell us a little bit more about that?
Oh gosh, great question because it is changing literally by the minute. So as you mentioned, many practitioners are filing habeas petitions. That's a federal lawsuit that's separate from the immigration proceeding, and it's called a writ of habeas corpus to produce the body. So essentially bring the detainee before the court, before the federal court to determine the legality of the detention. This is one way to challenge detention, and it has been successful in many jurisdictions. There was a class action that was filed called Maldonado Batista in the Central District of California at the end of 2025 that issued an order certifying a nationwide class of individuals who are detained, who are denied bond hearings. And there are those individuals that you were speaking about, Denise, the individuals who entered without inspection, but were not caught at the border. So perhaps they've been living here for 30 years and now they are being detained. So they're not subject to any other mandatory detention, but it's really just those individuals who entered without inspection. And so now, because of this class action, there is an opportunity for individuals to continue to challenge their detention. But what we were seeing is that that was not always being followed by the immigration court. So immigration court issued their chief judge issued an order or internal email policy essentially saying that this class action order did not need to be followed. Now, just as a couple days ago, on the 18th of February, there was an order that vacated that BIA decision Matter of Yajur Hurtado under the under the APA. And so because of that, we're having some success, but simultaneously, there is some litigation that's happening in the Fifth Circuit that also began a little bit earlier this month under a different matter in which they did adopt that BIA decision. So what we are seeing is a lot of movement in this arena. So I would say stay tuned. It's sure that there will be a lot more that continues to happen. And we also see that there are ways to challenge detention for individuals who have temporary protected status. They can also, they have specific provisions or a part of the statute that says that if you have TPS, you shall not be detained. So there has been some success, some declaratory relief in a litigation NTPSA v. Nome about Venezuelan individuals with TPS. And so continue if you're interested in this area of law. There's a lot going on. And when you watch this video, there may have even been more development.
Right. No, absolutely. Are there any other cases? Because we've been very focused on the question of this new interpretation of the statute that just came down in 2025 that makes people ineligible for bond hearings in immigration court that they used to have. But are there other kinds of challenges that can be brought in federal court? You mentioned people who have temporary protected status. What about people who have final orders of removal and are detained under a different statute for people with final orders, but have been there for a really long time because
Certainly.
removal isn't actually happening?
Right, certainly. And so you raise another great question. Those who are seeing prolonged detention or indefinite detention. So you can continue to raise challenges under constitutional due process violations. So in the space of habeas, there are many different challenges that one can raise, even as we were speaking about that Fifth Circuit case where it did adopt that BIA decision. It has not foreclosed that statutory claim to due process. So continue if you are practicing this space to make those challenges and follow the litigations that are happening around the country.
So maybe we should spend just a minute before concluding thinking about what ABA lawyers might be able to do on immigration detention issues. And obviously, we've just been speaking about one, which is get your habeas corpus tools and your membership in different federal district courts refurbished so that you might be able to engage in habeas work because there is great need and they are basic federal court questions, bringing challenges to detention under the statutes and the Constitution. I know another thing that the ABA Commission on Immigration is doing is just providing basic legal advice and counseling to callers who are stuck in immigration detention and have a range of questions. There some needs for individuals who speak Spanish and who have some immigration experience, but that is one other opportunity. Are there other ideas of how we can get people more involved?
Sure. I think videos such as these, sharing information about the nature of detention, looking for different resources, and educating as many people as one can about what's really happening in the context of immigration detention.
Yeah, great.
Anything else, Denise?
Those are all good ideas. It seems to me. I do think there's a lot of just lack of knowledge. There may even be local groups that are doing visitations to detention centers in your area that you might be able to join in and just speak to detainees, either as a kind of friends and family visit or as a legal visit, and that can be really eye-opening, and then provide information that can be shared more broadly too about what this is all about. I think
Exactly.
those are all
Well,
the thoughts that I have.
yes, exactly, exactly. Well, to everyone who joined us today, thank you for being part of this important dialogue. The issues we've explored are complex and challenging, but by coming together in spaces like this, we're taking meaningful action. And we encourage you to stay engaged with the ABA Civil Rights and Social Justice section and become a member if you aren't one already. Visit the website, explore upcoming events, consider joining one of our committees to help share the work that we're doing.